So in all, it started pretty strong. In all, the LegalZoom document started pretty strong. Some notable absences before we get into the analysis of it. Some notable things that happened there. So first, absences. They don't have nearly as much for dissolution. Their indemnification was toothless. So like, look how intense my indemnification process is there to protect the people that sign. My client who signed this document going to be protected by this indemnification clause. I am protecting my client to that clause. And they don't even have dispute resolution. Wow. Remember earlier, Gothgash said, so basically this is just a document to avoid disputes, and I was like, by and large, yes, by and large. They don't even have dispute resolution. It's like having a Pokemon movie without Pikachu in it, man. It's like not having Tobey Maguire say pizza time in the new Spider-Man movie. It's gotta be there. So that's really bad. It's not even referenced. What's really interesting is their tax section is really good. Like I really liked their tax section. They didn't have a confidentiality agreement. What I also really like about this section, my confidentiality agreement, is especially for software as service companies, especially for like Twitch streamers or anything like that, where you have a lot of what you're doing is very nebulous, very soft skills, where, I don't know, maybe the technique you use to respond to people on the internet, like maybe you have a really clever email method. I always reference that because I worked with a company that shared with me an incredibly clever email method that is like, it saves me 4 hours a week, every week. And that's confidential information that you can tell anybody. And as soon as you tell them, now they know. And it's not because there's sensitive information, confidential information, like how to make a patent or something like that, where it's highly technical, and if you gave it to a layperson, they literally probably would not know that it was sensitive information. They would not know what to do with it. And then there's sensitive information where it's like, literally anybody who hears this is going to be like, oh my god, that's a great idea. And so when you have the latter, which I think a lot of really good companies do, you're going to want to have non-disclosure agreement. This could be the entire non-disclosure. With some tweaking, you could make a non-disclosure agreement out of these 3 paragraphs. Why did I say that was really relevant to your software as a service or your Twitch streamers? Because a lot of techniques, whether it's discoverability or, again, just time-saving tricks, content creation, things like that, can be confidential information. And so if you give your company this section and they're out in the wild and they need to figure out how to really quickly, because they're going to go meet somebody and like, oh, we don't have a non-disclosure, and they just need to really quickly get one out, they can jump back to this agreement, copy paste this onto a page, work it out a little bit. Obviously they should talk to an attorney before they do that, but if they're in an absolute pinch, I mean, that's what a lot of this agreement is. If my client is in a position where they need something, this agreement is going to have a lot of it covered. They didn't even talk about disabled members. They didn't talk about death of a member. This, my favorite part. They didn't talk about it. That's why mine is 30 pages longer. Because they just didn't talk about it. I think the fact that they in 7.2 did not include the right of first refusal is insane. Okay. Yeah. So okay. So by and large, okay. So we've talked a little bit. We've gone through the documents, and let me get rid of mine. Thank you for participating. Let's talk about theirs. But I can't get more than one on the page. Okay, that's fine. Okay. Talk about theirs. I don't even know if this is closing thoughts. This is just conclusion. This is the conclusion. What do I think? Okay. Is it negligently bad? No. No, nothing like that. Is it negligently bad? No. Nothing like that. It would work. This is satisfactory, and it would work. This is something that if I expect... The thing is it's I guess, honestly, if somebody was like, you can buy a $600 operating agreement, or you can buy a $200 operating agreement, this looks like a $200 operating agreement. It looks like an operating agreement that somebody put together that is perfectly fine. It has a few issues with the sections of law that it references, but it works. And if you were really excited to get a company going, you've never spoken to an attorney before, you barely even know about attorneys. You probably think that they're all $10,000, and to talk to them is going to cost you, an arm and a leg. And there's sort of that fear of speaking to attorneys. Yeah, I think I can see why this would be attractive, and I think it would be a little bit of a trap. But for $200, that's exactly what I would expect you'd get. So here's sort of why do I come to that conclusion. First, let's talk about the pricing model. It's $200 for this, right? But we looked at everything, and there's a $300 difference between my service and this service. And the thing that leapt out to me about the LegalZoom service is that they had several recurring annual payments. Registered agent, which you don't need unless you're making a company out of state, and the business formalities, which is your annual meeting, which you don't need an annual meeting. You can have in your operating agreement that you don't want one. And you don't need minutes. You do not require minutes for your annual meeting. So you do it for a corporation. If you have a corporation, you're going to need an annual meeting, and that's a whole different thing that might be more worth it. And so I think that's probably why they included the S-Corp thing, but we'll get to that. Talking about the pricing right now, the fact that they charge was like $520 a year for two services that you don't need, that is where LegalZoom, I think, ends up becoming more expensive than an attorney. Because your attorney, I cost $600. They cost $280 or something? Or $320 more for me. But then the next year you're paying that $530. So now boom, you're already paying more in the second year. And that's if you only use them for 1 year. You use them for, like, let's say 3 years. What is the average lifespan of an LLC? Let me just see. Average lifespan of multinational Fortune 500 companies tend to be 40 to 50 years. Average lifespan, well, their lifespan is only 100, right? Or no, their lifespan is only like 78 years, because they included that it has to dissolve in 2100. Let me see. Okay, this isn't helpful at all. I just want to know, how long does a typical LLC last? I'd imagine it's pretty short. I'd imagine it's like... Alright, I don't see it online, so I'll just use my anecdotal experience, which is not as good, but I'll tell you, probably 4 years. 4 years for a bad company. For a company that isn't going to last, it's going to happen in 4 years. It's going to be created, fall apart in 4 years. For a company that's going to last, it's probably going to be like 50, just forever. So let's say 4 times. I don't usually use my math section, so very unused to accidentally hitting my other stream keys with those buttons. Those are my 10 keys. It's like my math zone. It's $2,080. You end up spending $2,080 on LegalZoom, if you operate for 5 years, no, for 4 years, if you operate for 4 years at their $520 annual fee, you will end up spending $2,080. If you work with me, you spend $600, and then as needed. But of course, if any of those issues come up, that those as neededs come up, you're going to need more services from LegalZoom anyway. So that's just, and that's if your company only lasts those 4 years. If it's like a bit of a bust. So that's probably who they're targeting with that service. So I imagine they make between $1,500 and $2,000 off each transaction of just profit, just pure profit. That's not looking at the state fees or anything. I'm only looking at the registered agent annual subscription cost. I'm looking at their business formalities annual subscription cost. So I do that analysis because I'm like, man, if it were like $100 for this operating agreement and that's it, and you never had to worry about anything else, and there was no other like slightly predatory fees associated, okay, I mean, it's okay. LegalZoom's got a great setup there though. It's gonna make them some money. You're not going to get a client that's in the best position. So let's talk about the document itself then. So we're talking about the, all right, I think it's going to be like a 4-year company if you make this thing. It's probably a college kid. It's probably somebody who doesn't know too much about the environment, is new to a young entrepreneur who jumped out, wanted to get something going, you know, probably told themselves things like, okay, well, let's not let good be the enemy of, let's not let perfect be the enemy of good. Things like that. You know, like they just told themselves their business mantras and, threw this together and did not have an attorney working with them, didn't have an accountant working with them. What are some of the things that are going to be good? What are some of the positives? Let's talk about that. Well, it works. It's cheap and it works. You get your thing. I wish it were cheaper just looking at it, but you get your thing and it does work. It's perfectly acceptable. You have this document that you can save. Not only that, but you also have LegalZoom, so you can always go back and check. I'm sure it's probably stored there somewhere, and you can always go back and check it. Well, if you have an attorney, they'll store your documents for, I think, a minimum of 7 years as well, so that's not really a benefit to LegalZoom. I really liked it so much, I actually sat down and tried to put some of that, or I didn't try, I put some of that language in my agreement. I liked it so much when we got to their, where is it? This subchapter S election. I love that. That's really good. That is really clever. Why? Because that is exactly the kind of thing that a young entrepreneur, a startup company who doesn't know anything really about the field, who doesn't have their own tax person, they're going to wonder about this. Because if you Google how to start an LLC, all of the things are, well, you can be an LLC or a corporation. So when you see at any point you can switch, that gives them peace. And when we talk about what an attorney does, an attorney, you go to an attorney to get peace. They are merchants of peace, right? You go there to be told what to do. They're counsel. They're your advocate. So when I see a line like this, that's a line that's taking care of their client. This is good lawyering. This is well done. The fact that this was in there, I like it a lot. And I also think that there's also a technical proficiency here where we're representing the S election, telling people, no, you don't have to be a corporation to get the S tax, the S election. You can elect to be taxed as if you were an S corporation. It's just a tax election status. That gives them a little bit of, I mean, that's a bit of proficiency. That is a bit of expertise that everybody should have, but not everybody does in the entity formation business. So great. 5.4 is great. Tax Matters. I mean, the fact that I love that this is here. It is not called a Tax Matters member anymore. It's called a partnership representative. I love that. However, if it is a single member LLC, you won't need this. You'll just straight up cut that because you won't want it. But I did like that was there, minus those issues with it. And then banking, I liked that was there. All three of these. I put all three of these. in my agreement. Because, I mean, what is this? Most of the people that use these things are going to have a tax person. Because if you're making a company, you probably have a tax person. That's not their target audience. Their target audience is people have brand new to it, probably college kids, probably just out of school. But even so, there's a cross section here. Because these rules, these things are super beneficial to people who have tax people, but those tax people are personal attorney or personal accountants, so they don't know how to do company law yet. So you give them these, three, and they basically just lay out how to do it. Be taxing like a partnership. They'll be banking all in one place. You can elect a subchapter S. These sections, I think you read those as a client and you're given a sense of peace. You're given a sense of I've listened to and my needs are being met before I even know them. Because these are probably the things that are scariest to new people, to new companies. It's how to do the taxes. But one of the scariest things to Twitch people, right? And then we got into it's about the end of the positives because then it turns into a fucking disaster. But let me see, before we get to that. Yeah, the rest of it, I think we had a couple sections. We had fine. This is really weird. Remember, because they're like, oh, you can pick A or B. You don't have that in your agreement. You have that in a template. But again, this is a template, so I'm willing to let that one slide. The final agreement, you would pick one. You'd sit down with your client and pick one. Yeah, I think it's fine. Fine. Great. And then, okay. Oh, right. Officers is where it really started to go. Okay. So officers is where we saw the first shake, right? Where it was like, okay. All right. This is a problem. And the reason is that I don't know why this is a single paragraph. Right? This is without other cross references. This section is imbuing members with the ability to do anything they want. Potentially. Why don't I think they've changed it? Probably because they don't have many companies that use these operating agreements and then become incredibly successful. But if you have a company that becomes successful, where there's millions of dollars on the line because your company really exploded, really, it's making that kind of money, then normally good people who have the opportunity to make a few $1 million by being overly pedantic, they're not even stealing, right? Because it's right here. It's just technically right here. And here's what I mean, right? We talked about it. The members are authorized to appoint one or more officers from time to time. This is not defined as consent of members, as it's just people in the company. So it doesn't say a majority of members. It doesn't say unanimous members. It's just the members, which could be as few as, technically reading this, 2 people who are members. They may have between them half a percentage interest. But because they are the members, they are authorized to appoint one or more officers, and the officers will have the title, the authority, and the power to perform duties that those members determine. So, like I said, 2 people with 1% interest could elect themselves president and secretary, and say that the president and secretary has the ability to distribute funds. And here's the thing, do I think that argument would hold water? Probably not. Like, they would probably go and read in a reasonable reading of this. But if it's worth $1 million to try that, and court only costs $10,000, I'd sue. Who wouldn't sue in that position to try to get that? And that's where the transactional attorney has failed, because you've got your clients in a position where they're probably going to court. So this needs way more specificity. This is a disaster. And that is a theme. Again, love this part. Thank you. That was great. That continues here. This is this part right here. So I know that I said it's doable, it works. If you were a single member LLC, brand new, and you only intended to run this thing for like 3 years, okay, whatever. It's because this line is probably not going to be an issue, but this is a danger. This line is putting your clients in it at risk. Because a member may transfer membership interest to any other person without consent of any other member. Like I said, that means the 30% interest holders who are not supposed to be in charge of the company. Right, so you could have, let's say that you have this you're the Twitch streamer and you have 2 mods. That was actually a great example. You're a Twitch streamer and you have 2 mods and you're trying to make a stream team together. You're the streamer and you're the one who started the company. You're the one who put up the money for the company. You're the one that does all the work, makes everything happen. But the mods are there to do some administrative stuff. They do some things, but you've given them 30 and 30 and you've taken 40. Because, you know, sure, you're just an equitable person. That's the way you roll. And you really appreciate what they do and how frequently they are there, and you just feel like, okay, yeah, I mean, this is realistic that this could happen. So you go 40, 30, 30, or like, let's say you have another example that's probably even more realistic. Let's say you go 40 and then 6 mods and they all have 10%. So that way no other mod is really being given a lot, but yeah, okay, 10% for all you guys. Thank you for everything that you do. And something happens where you become huge. You become a huge streamer. You're worth $1 million, millions of, let's say 10 million bucks. Let's exaggerate it for the point. Let's say you're worth 10 million bucks, and your mods get together and say, if we can take control of this, we can get all of that, because all of it's going to the streamer. Almost none of it's coming back to us. We could take control of the company, have it all come to us. Vote the streamer out. How do you do that? If all 6 of those people sell all their membership interest to one of them, giving one of them 60%, you only have 40. Because there's no restriction on transfer, there's nothing you can do about that. And that, I bet you would lose that if that went to court. I bet that you would actually lose that, because this contemplates that. It's like, yeah, that you signed this. That's not even a creative reading. That's just exactly what it says. So yeah, this section is a disaster. For any company that has any hope of continuing or being successful, this language is a disaster. Dissolution was fine. Indemnification, totally toothless. Why? Because this says the company must defend, indemnify, and hold harmless a company agent in connection with the proceeding in which such company agent is involved, if and to the extent state law requires it, a limited liability indemnify company agent. So you have to indemnify somebody if and if only state law requires it. New York state law does not. So you don't have to indemnify. This whole section doesn't mean anything. You don't have to do it. 9.2 says you don't have to do any of it. Which is great. If you're a buyer of this company, that's really good, because that means you don't have to worry that, like, if 10 years down the line it turns out that prior owner Bobby did something wrong, you can say prior owner Bobby did something wrong when they own this company. Go after them because they did it. But if you're prior owner Bobby, if you're the person that wrote this agreement, that paid for the company, that made the company, this is not what you want protecting you when you go to sell it. This is like, this language does not, it's baffling as to how this language ended up in an operating agreement, because this looks like language that you would have in a merger and acquisition, where the seller does not have as much leverage as the buyer, or that leverage is used someplace else. This is really pro buyer language, and we are not in a purchase, so I don't know why that's here. And then this one doesn't allow for certified mail, or it doesn't allow for for email. Super weird. And then where was it? It was this one. It says that every document referenced by this agreement is in this agreement. This document says every document that's happening prior to, references all agreements that are happening prior and contemporaneously with this agreement. So we've just referenced those documents. This says all reference documents are not, or all prior agreements are not part of this agreement. This says all reference documents are part of this agreement. So when you reference documents that are not part of this agreement, that's a contradiction. Not as bad. I think, honestly, it's the officers section, the indemnification section, and this section that are just like, whoa, like I don't understand what's happening here, with an emphasis on this one. This one is just absolutely terrible. Is it possible though that it's not going to be an issue? Absolutely. And this is what I was kind of saying, is those will only trigger if your company becomes, if you sell your company for the indemnification, or if you have enough money in your company for people to be inspired to behave like that, to attempt a hostile takeover. And no one's going to attempt a hostile takeover over a company that doesn't have anything going for it. So, was it for companies that don't have anything going for them? If you believe that you're a company that has nothing going for you, LLC, operating agreement from LegalZoom, perfect. If you want a chance of success, you're going to want to hire a lawyer.